Generally, a plaintiff may bring a replevin action to recover the possession of personal property that's wrongfully detained by another. But may a plaintiff also recover incidental damages that he or she incurred as the result of the property being wrongfully detained? The Wyoming Supreme Court considered this question in Cross v. Berg Lumber Company. In 1989, George Berg, owner of Berg Lumber Company, purchased a motor grader on the company's behalf for road construction, grading, and maintenance work. 2 years later, Berg moved the grader to the company's sawmill in Casper, Wyoming. At the time, the company had hired Joe Crail to deliver logs to its sawmill. In October or November of that year, Crail took the grader to Richard Cross's ranch without the company's permission and used the grader to grade access roads for logging activities. After learning that Crail had taken the grader, Berg asked him to return it. Crail agreed to do so, but he never returned the machine. In the spring of 1992, Crail told Berg that he'd left the grader at the Taylor Ranch and didn't have the money to hire someone to bring it back to the sawmill. Berg then drove to the Taylor Ranch to search for the grader, but later learned that the grader was still on Cross's ranch. While on Cross's ranch, Cross asked Berg if he could use the grader to repair the damage done by Crail to his property. Berg said yes and told Cross he'd pick up the grader when he was done. However, when Berg tried to retrieve the grader, Cross wouldn't give it up. Subsequently, the company sued Cross in state district court for conversion and replevin. Following a bench trial, the court ordered Cross to return the grader and awarded the company $83,400 in incidental damages. The damages were for the costs of engine repair, replacement of the cutting edge and batteries, tire replacement after depreciation, attempted recovery, and loss of use based on the monthly rental value of the grader. Cross then appealed to the Wyoming Supreme Court, arguing that the court's damage calculation exceeded the quantum of the company's injury.